So we're going to talk about sovereign immunity today. Time to do some training on sovereign immunity, judicial immunity, prosecutorial immunity, absolute immunity. We need to talk about that. So we're going to talk today about immunity. There's a lot of rumors that are going around, a lot of things that are being said by our government officials that say that they are immune. And while that's partially correct, we need to repel some of the rumors, all right? Because we need to start to address this. We need to start to fight back. But in order to do that, you guys need to understand the history of immunity and what it actually means, because it does have good rational thought to a certain extent, all right? I'm going to try not to read comments right now because I don't want to get sidetracked. Maybe I can come back and answer some questions along the way. So last night we did a Republic interview, and that was a good interview. It looked like there wasn't a whole lot of people on there, but if you guys were, then hopefully you guys came away with some good information. When I finish what we're talking about here with the immunity and the history of it, then maybe we can come back and you guys can ask some questions directly and I can respond to them. So again, you guys know that I deal with law enforcement. I deal with the enforcement element. I don't deal with the adjudication. I'm not an attorney. I'm an advocate. I specialize in substantive law, which is criminal law, and not in civil law. Attorneys specialize in civil law. And so, a lot of you are pursuing a 1983 civil suit. And that's great. That's great to hold people accountable for the things that they do for civil liability. But unfortunately, you guys are running into issues of this whole immunity thing. And we have Stephen Miller talking about, immunity of public officials, absolute immunity. Therefore, they're absolutely immune to do whatever they want to do within the course of business. And that's not correct. Okay, so let's break down sovereign immunity here. Okay, the history behind it is English common law. And it's built upon the theory that the king can do no wrong, all right? The king can do no wrong. So in England, in traditional British, they have a monarchy. And that monarchy he makes the laws. He's sovereign, all right? And through his sovereignty, he cannot be sued. He can't be arrested without his consent. Because if you come to him and you say, well, sir, you broke the law, all he has to do is say, no, I didn't break the law, and he changes the law. So as the sovereign, monarchy, he's able to, claim immunity from civil and criminal liability because he is responsible for the law. So you can't sue the king, you can't arrest the king without his consent. That is the English doctrine that the king can do no wrong. And in England, the king granted all of his agents immunity as well under his authority. So he said, well, my prosecutors and my judges and anybody that works for me is immune and sovereign, and you can't arrest them either. You can't sue them either without my consent because I grant them immunity. But that's not what we created here in America. Now, we did establish our Constitution and our principle of law, our legal doctrine based upon English common law, right? And so we did provide immunity of government, but the immunity is, again, absolute immunity, judicial immunity, prosecutorial immunity. Now, the problem is that there's two different types of immunity. There's immunity from civil law and there's immunity from criminal law, right? Those are two separate things. So if you were to go out and you were to read absolute immunity on, Cornell's LII or even a Black Law Dictionary, if you were to pull it out and read it, absolute immunity says immunity from civil liability for the conduct performed within, their business. Civil liability. It doesn't say anything about criminal liability because these are two separate things. So there was a case at the United States Supreme Court, 1976, Imbler versus Pachman. That's IMBLER versus PACHTMON. Right? Imbler versus Pachman, 1976. This was a unanimous decision by the Supreme Court, so there wasn't even a dissent. All of the justices of the United States Supreme Court agreed with the assenting opinion. And in the assenting opinion, it was in 1983 that was brought up from Mr. Imbler, and he was challenging prosecutorial misconduct. He wanted to sue the prosecutor for their misconduct that they did in the performance of their business. And the Supreme Court came out and said, "Oh no, they have absolute immunity." But in this particular ruling, again, 1976, and the citing is 424 U.S. 409, 429, 1976, Imbler versus Pac-Man. So what the court did there was they clarified the fact that there's a difference between civil liability and criminal liability. And let me just pull a paragraph out of this because this helps illustrate this issue here. He said, this was a unanimous decision, all right? So we emphasize that the immunity of prosecutors from liability in suits under 1983 does not leave the public powerless to deter criminal misconduct or punish that which occurs. This court has never suggested that the policy considerations which compel civil immunity for certain government officials also place them beyond the reach of criminal law. Even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights on the strength of Title 18 USC subsection 242, which is the criminal analogy of USC 1983. They also cited O'Shea versus Littleton from 1974, as well as also Gravel versus United States 1972. You see, the doctrine of master-servant, right? The doctrine of master-servant, what it says that a servant will perform mechanical duties on behalf of their master. And in the course of their duties, they will always side with what is in the best interest of their master. So let's break that down. The doctrine of master-servant says that they will always do what is in the best interest of their master in the course of their duties. So a state judge is going to do what is in the best interest of the state because he is an agent of the state being the master. This is also the argument behind, our original jurisdiction litigation, right? That state judge is going to side with state interests and biases and prejudices because he works for the state, because of the obvious conflict of interest that exists, right? This is very simple here. But they will always do what is in the best interest of their master, meaning that they'll always do what the master tells them to do. So if the state creates a law that directs them to disobey the Constitution, that is in fact a violation of Title 18 USC subsection 242, as the court identified, right? They said that they're not beyond the reach of criminal law under the strength of Title 18 USC subsection 242. They can still be held criminally liable for willful deprivations of constitutional rights under the strength of Title 18 USC subsection 242. And what 242 says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. So if the state creates a law that directs their agents to disobey the Constitution, that is an unconstitutional law, which means if the agent relies upon an unconstitutional law in the exercise of their duties, they just committed the crime of deprivation of rights under color of law. And when two or more persons conspire or participate in the deprivation, such as a judge conspiring by and between the prosecutor and the sheriff's department, and now county commissioners and city councils because they're paying for the budget, now we have all of them enjoined. Each one of them is a member of the criminal conspiracy, as a result of their actions. Now, this is not just negligence versus willful criminal conduct, because in constitutional realm, there is no right to self-defense when it comes to a breach of constitutional obligation. If you don't do what the Constitution requires you to do, you have already implicitly invited punishment should you fail to fulfill the promise that you made. That's the effect of the oath. So again, a public official, right? All that a judge is doing is they're obeying their master, right? And this is the concept behind the American absolute immunity, is that you don't hold the agent civilly liable because they're just doing what the master told them to do. The state created a law and they're just doing what the state told them to do. But you can't hold the state criminally liable. You got to hold the agent criminally liable because there is no immunity from civil liability, even from the United States Supreme Court, 1976, Imbler versus Pac-Man, unanimous decision. They said it right there. that what compels the court to absolute immunity and the protection of agents from civil liability does not hold public harmless from being able to hold people accountable for the crimes they commit, because they are still subject to criminal law under Title 18 USC subsection 242, which is exactly what we are doing here, right? Now, this is a big deal. It's a very difficult thing to do, and I understand that this is taking a long time and that people are getting frustrated by how long it takes, but we have a massive number of people who have been led astray into thinking that, one, they can do whatever they want, criminal or otherwise, and they're immune, right? Which is absolutely not true, right? But we also have, all of these people that have been led astray for 243 years by a court that has told them that the Constitution doesn't apply to them, which is also absolutely insane, because the sole purpose of the establishment of the Supreme Court of the United States was to preserve, protect, and defend the Constitution of the United States. So you got to understand, absolute immunity does not make the agent immune from criminal liability. It tells you that you cannot sue them. And if you went out again to blacks and you were to read absolute immunity, judicial immunity, prosecutorial immunity, sovereign immunity, every single one of them says that they are immune from civil liability, guys. And I want you to go out and read this. I want you to do this on your own, because you'll understand that when it says civil liability, that is separate from criminal liability. Now, this is the problem that you guys are having in your 1983 suits. As you come forward with a 1983 suit and you say, oh, well, I have, I've had this damage occur to me by this agent, and I want to sue for damages. Well, the catch-22 that you find yourselves in is that they're going to dismiss it for sovereign immunity. They're going to dismiss it for immunity. They're going to say that agent is immune civilly because you brought forward a civil suit. You didn't bring forward a criminal suit, right? Those are two different things. Two different courts with two different functions with two different types of immunity. There is no immunity here in America for criminal liability. No one is immune from the crimes that they commit. That is an English doctrine that does not exist here in America, right? So the way that it's supposed to work is that you don't sue the agent for what the agent did. You sue the agent's master for telling the agent to do what they did. But before you can sue the agent's master, you got to first show that the agent broke the law. Otherwise, there is no damage that exists. That's why all of you are getting a response back from the court on your 1983 suits that says, hey, the petitioner failed to state a claim upon which relief can be granted. They can't grant you relief unless you show that their agent actually did something wrong. And you can't sue the agent, right, because they have absolute immunity, because they have civil immunity from civil liability in the course of their business. The agent is just doing what the master told them to do. If the state created a law that says you don't got to do what the Constitution says, and then that agent relies upon the state statute to abridge what they're obligated to do in the Constitution for the United States of America, they just committed that crime. Deprivation of rights under color of law. And again, when two or more people do it, now they have a conspiracy to deprive rights, and so on. So again, under the immunity doctrine, you don't sue the agent, okay? You sue the agent's master. But before you have civil liability, you have to deal with law enforcement, which again is why I do what I do. I deal with the first part. That's why this is so different than what a lot of people are aware of, is because you're listening to an attorney does the second part. They go in and they sue, right, civilly, because they're an expert in civil law, but they're not an expert in criminal law. That's me. I'm an expert in criminal law. Before you can sue, you first must hold the agent criminally liable for the crimes that they committed, and that gives rise to relief, right? It gives rise to liability. You can't show that liability exists until you show that someone broke a law, and therein lies the criminal liability. So you can't put the state in jail, right? You can't charge the state with a crime, right? You hold the agent of the state criminally liable for the crimes that they committed. And then once you do that, then you can sue in a 1983 suit, but you don't sue the agent, you sue the master. That's where you're going to get your money. That's where you're going to get your relief. if the state participated in the deprivation of a fundamental constitutional right, there is absolutely liability that exists. Absolutely, everybody knows that. But how do you show that the state participated in the act of a deprivation of a right? Through the apparatus of the state, which is the agent. The agent is the one that's performing mechanical duties on behalf of their master. And in the course of their duties, if they break the law, they committed a crime. If they deprive a person of a right that's guaranteed by the Constitution of the United States of America, they committed the crime. And if they commit a crime in the conduct of their business, then there is no immunity from that criminal liability. So now we're in a situation where we're like, okay, what do we do? The FBI won't do anything about this, right? The attorney generals won't do anything about this. The courts won't do anything about it. The right to an indictment by a grand jury exists because the state has the obligation to do it, and the agent of the state failed to do it. Deprived you of a right that's guaranteed by the Constitution under the authority of a state statute, which is unconstitutional, meaning that the state statute doesn't even exist. Refer to Norton versus Shelby County, United States Supreme Court. With regard to the unconstitutionality of a statute, any unconstitutional law is not law at all. It provides no office, no protection. No court is bound to enforce it. No person is bound to obey it. It's as inoperable as though it never even existed. Not from the moment that it was deemed such, but rather from the moment it was created, as though it was never even created at all. Norton versus Shelby County. So if the state creates a law, right, that is unconstitutional and then directs their agents to obey that law, that agent has an obligation to obey the Constitution of the United States of America, not the inferior state law, right? And again, this is also codified in the United States Constitution, right? The Constitution of the United States of America. It's codified in the Supremacy Clause, where it says that the judges in every state shall be bound thereby anything in the Constitution or laws of any states contrary notwithstanding. And remember, I brought this up numerous times. The Constitution in the Supremacy Clause is not referring to federal judges, United States judges, because just prior to that, in Article 3, it says the judges, both of the United States and of the several states, shall maintain their office while in good behavior. So Article 3 has identified the existence of United States judges and state judges, and it has bound them to maintain their office while in good behavior. So when the Supremacy Clause says specifically the judges in every state shall be bound thereby anything in the Constitution, that was not referring to United States judges. Otherwise, it would have said it, because Article 3 has already identified the existence of United States judges and state judges. So the Supremacy Clause absolutely binds state judges to adherence to the obligations of the Constitution, even in instances in which the state law is contrary to the Constitution of the United States of America. This is, again, employing what is called preemption. Every public official, when they run into an instance where there is a conflict of law, they must employ preemption, which is the process to determine what law is supreme. What law do I follow? And if they make a decision to follow an unconstitutional law or an inferior law in violation of a superior law, then that preemption does not mitigate their culpability or liability in their criminal conduct through the deprivation of rights under color of law. No state has the authority to be able to create their own alternative legislation, substitute that for the guarantees of the Constitution of the United States of America, and then go out and enforce it as though it's constitutional. And this, again, is codified not just in the Supremacy Clause, but also in the 14th Amendment. The 14th Amendment is extremely important because the 14th Amendment binds the states to adherence with the limitations of power that the Bill of Rights provides. Because what the 14th Amendment's Privileges and Immunities Clause says, not the Due Process Clause, the Privileges and Immunities Clause, that is the clause that you all must use. If you're coming at the government, do not use the Due Process Clause, the 14th Amendment, because it is subjective and it's arbitrary. All right, subjective and arbitrary. The courts have traditionally used that as the provision to determine incorporation, but it has also been used as a weapon to say, oh, this isn't protected under due process, because what is due process? Due process is whatever the court says that it is, because it's not tangible. There's no substance to it that we can link onto like you can the Privileges and Immunities Clause. All right? Because the Privileges and Immunities Clause says that no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. Okay? No state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. Now, the United States Supreme Court came out in 2019 in another unanimous decision. It was Timbs versus Indiana, TIMBS versus Indiana. And what they said was that they said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. All right. So, in other words, if it's written in the text of the Constitution of the United States of America, that is at a minimum what every single United States citizen is guaranteed, regardless of where they choose to reside within the jurisdictional United States. So, with regard to this grand jury issue, right, if no state can create or enforce a law which abridges the privileges and immunities of United States citizens, and the Supreme Court comes out and says, well, the privileges and immunities of United States citizens are whatever's written in the Bill of Rights, then the grand jury clause is written right there. So how is it that the state of Washington or the state of Connecticut or the state of Pennsylvania, the state of Michigan, the state of North Dakota, state of Oklahoma, state of Florida, state of California, state of Texas, how can they create a law and then direct their agents to enforce that law, which abridges the privileges and immunities of United States citizens, because the indictment by a grand jury is in fact enumerated within the Bill of Rights, and that is at a minimum what is guaranteed to every single person, regardless of what jurisdiction they choose to reside within. Okay? State citizen, it still applies because you're still a person, right? Because the Constitution says no person, right? And so as a person, you are guaranteed at a minimum what is contained within the Bill of Rights. Absolutely, 100%. So it really doesn't matter, which direction you go. And I talked about this a little bit yesterday on the Republic when I was on there, and why I took the path that I'm on, and why I'm relying upon the 14th Amendment, why I claim citizenship and so on. Part of it is the fact that I am under oath. So I don't get to go a different path, right? That's the path that God has me on. But in my opinion, it's a winning path because the privileges and immunities of United States citizens are not granted by the government, right? This is the argument that we often hear ourselves in. Oh, government doesn't give me a right. It's not a privilege. No. The Constitution gives you the privilege, right? So we the people guaranteed our privileges and immunities through the Constitution. It wasn't granted by the government, because before the government existed, we created the privileges and immunities through our founders and forefathers. So the privileges and immunities were created by them. So it would apply. It would apply to state citizens, state nationals, just as much as United States citizens. But I had to take a very, very specific path because I do have limitations in my ability to be able to do it. Under oath, I'm part of the corporation, and as part of the corporation, then as part of the corporation, in order for me to maintain my honor, I have to maintain my citizenship. So I didn't have a choice to be able to go a different route, right? And I'm not saying that anybody's doing anything wrong. I'm just simply saying that for me, I chose the citizenship path because of certain obligations that I had. I can't walk into the courtroom and exercise my rights as a shareholder of the corporation if I gave up my interest in the corporation. So by having interest in the corporation, by being a shareholder, I can walk into the boardroom, I can demand a board meeting, and they will have no choice under the laws, corporate laws, to be able to deny me that right, because I am a shareholder as a citizen. So when I go into the Supreme Court, when you go down a path of giving up your citizenship, what you're also doing is you're giving up your right to participate in the corporate entity. Okay, I don't like the corporate entity. This corporation absolutely needs to be shut down, and it needs to be bankrupted and finally, and we need to put into place something that's going to suit the people more than a corporation that's wanting financial interests and so on through the enslavement of people. I agree with that. But in order to shut it down, we got to go from the inside to do it. All right. And that's why I maintain my citizenship. And I would welcome all of you to head down whatever path you think is right for you. But we have a winner on this because I am a part of the corporation. And because I can walk into that corporation, I can demand a board meeting, and they have to have it. And in doing so, there's certain things that we would have, certain advantages that we would have that we wouldn't have otherwise if I went a different path. I would also lose my honor if I violated my oath by not supporting the current corporation. All right. I'm not seeking destruction of anything. I want the people of the United States to get their property back. I want people of the United States to be free. And remember, the laws were not created by government. The laws were created by the people before government created. So government is a creation of the law, of the Constitution. Government did not exist before the law. And we, the people, in our sovereignty, we created the law. Therefore, the government is a creation of the people, and that which is created cannot be above the creator. This is a very simple concept of creation. That would be an argument that would be too absurd to even consider. It would be like saying that the peasant is above the king, and we all know that that's not true. We, the people in our sovereignty, we created the law. The law then created government. Therefore, we are not a creation of government, and that which is created cannot be above the creator. And so that's where that's what we need to remember, is that the law was created to restrain government. It was not created for government to have power. The law is there to protect the people. It's not there to protect government. And so we need to understand that the law is our weapon. It's not government's weapon. And so when the law says something, that's the limitation of power that exists. And the law says that absolute immunity does not protect people from criminal liability. Doesn't do it. Okay, it doesn't do it. It only protects people from civil liability, not criminal liability. So again, the course of action that you all need to take, or you all have to, is that before you can sue civilly, before you can hold someone civilly liable, or an entity civilly liable, the master civilly liable, you must first hold the agent criminally liable. And once you show that the agent broke the law, committed a crime, then you have the ability to sue under 1983, and there is no claim of immunity because the liability exists now. But absent the first step, absent law enforcement, absent the criminal conduct being identified, there is no right to be able to sue in the civil capacity. And they're going to just dismiss it and say immunity exists, and you guys aren't going to understand the reason why they keep on dismissing it, other than the fact that attorneys don't know this first part. Attorneys know the second part, they don't know the first part. So if you, just as I said, United States Supreme Court, Imbler versus Pacman, that's 424 U.S. 409, 1976, unanimous decision. The court emphasized the fact that what compels them to considerations for civil liability of prosecutors and judges and all, police officers and all the rest, what compels them to immunity from civil liability does not make that agent immune from criminal liability or out of reach of criminal law, particularly under Title 18 U.S.C. subsection 242, which the court specifically addressed, specifically said. So again, we emphasize that the immunity of prosecutors from liability in suits under 1983 does not leave the public powerless to deter misconduct or to punish what occurs. This court has never suggested that the policy considerations which compel civil immunity for certain government officials also places them beyond the reach of criminal law. Even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights, particularly on the strength of 18 U.S.C. subsection 242, which is the criminal analogy of subsection 1983. So you can hold the agents criminally liable for the crimes they commit under Title 18 U.S.C. subsection 242, but you can't hold them civilly liable, all right? So the first step is we got to get the criminal conduct identified, right? We have to do that first. Then once we do that, that gives rise to the civil liability for all of the attorneys and everyone else to file 1983s. Absent the first step, absent law enforcement, absent the criminal liability, you have no grounds to sue. You have no grounds to sue. The case is Imbler versus Pacman. That's IM. Can someone please type it into the boxes? IMBLER versus Pacman. PACHTMAN. MAN. That is 424 US 409 to 429 1976. Imbler versus Pac-Man. Okay? So another thing that we need to remember is that government can't be delegated powers that the people do not inherently have. So if the people aren't immune, we can't delegate immunity, right? And under our system of government, we did not say that the people are immune. People can be held criminally liable for the criminal conduct that they commit. Every single person, because no person is immune from criminal liability in our constitutional government. Therefore, we cannot delegate to government immunity from criminal liability because we inherently don't possess that power. We can only delegate powers to the government that the people inherently have. If the people don't have the power, we can't delegate the power. So government can't assume, immunity from criminal liability because that is not a power that is inherent to the people. So there's another nuance to this that I want you guys to understand. Another nuance, and this goes again to word etymology and the origin of words. So here in America, if you choose to violate the law, you incur a debt to which you are charged and called to account so you can pay the debt. That is our criminal law, right? If you break the law, you are charged and called to account, right? So you have a trial and so that you can pay for the debt that you committed. So, but the way that you initiate a criminal adjudication is called a bill of indictment, right? That's because this is an economic-based system. You all know it is. And those terms that I just brought up, if you violate the law, you incur a debt that is owed to society, to which you're charged, called to account, so you can pay the debt. Those are all accounting terms. Pay, debt, account, charge, those are all accounting terms. So again, in accounting, before you can be charged for something, you must first be billed for something. Absent a bill, that would mean that the charge is fraudulent because you must always bill someone before you can charge their account. But it's a very simple method for transactions that anyone can understand. Very simple accounting terms. However, if someone charges your account without billing you first, that is called fraud. You must always bill before a charge is generated. Absent a bill, then that charge becomes fraudulent because you didn't bill someone first. So a bill of indictment is what initiates a criminal charge. You cannot be charged before you're billed without that agency committing fraud because the bill must come before it. That's why a bill of indictment initiates the charge, right? Which then allows for them to call you to account so that they can validate the debt and make you be responsible for payment of that debt. So the bill of indictment is what initiates a criminal action. Well, in England, a king is known as nobility. Nobility. A king is noble. The origin of that word is that you cannot bill a king for his crimes because he is nobility. He has no bill, or he is no bill. And that is the origin of that word. Nobility means you cannot bill the king for his crimes because he is nobility, right? This is why you can't hold a king accountable because he has nobility. You cannot bill him for his crime because he has nobility. And that is the origin of that word. Now, the problem there is that Article 1, Section 9 says that the United States of America shall not create patents of nobility, meaning that no U.S. agent of the United States government can have nobility. They're all accountable for the crimes they commit because otherwise that would be nobility. And there cannot be nobility here in America according to Article 1, Section 9. Now, Article 1, Section 10 says that no state can create nobility. So no state agent, no state judge, no state prosecutor, no state law enforcement, they can't have nobility because every one of them is billable for their criminal conduct. They're billable for the crimes that they have committed. So if you say that a state judge can't be held criminally liable for the crimes that they commit, you're saying that they're no bill. You can't bill them. And that would be a violation of the Constitution of the United States of America. It would be a violation of Article 1, Section 9, for if it were a United States judge, and it would be a violation of Article 1, Section 10 if it were a state judge. Judges cannot have immunity from criminal liability because everyone here in America are billable for the crimes they commit. No agent can have nobility. And the Supreme Court came out and said that. 1976, Imbler versus Pacman. That even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights under the strength of Title 18 U.S.C. subsection 242, deprivation of rights under color of law, which is the criminal analogy of 1983. So again, even the Supreme Court in this ruling identified that there is a civil statute that relates to there's a criminal statute that is analogous to the civil statute. Why are those two enjoined? Because you sue the master for the criminal conduct of the agent. So if an agent commits a crime, he is fully billable for the crimes that he committed under deprivation of rights under color of law, Title 18 U.S.C. subsection 242. And once you hold the agent criminally liable for their breach of constitutional obligation under the semblance of law being a state statute that is not actually law because it's unconstitutional, then you file your 1983, and you file the 1983 against the agent's master because the agent is simply doing what the master told him to do. Master said, here, agent, go out and enforce this law, and they're just simply doing what their master told them to do, but ignorance of law is no justification for having broken it. So just because the state creates a law and says, agent, I want you to enforce this, that agent has an obligation under criminal law to make sure that they're not acting criminally. Okay? Over here, this is YouTube, I believe. And on YouTube, this will be here. You got to go to my page, and then from my page, you'll go over to live, and then the live video will be there. So this will be, all of my live videos are all there. And I understand I need to do a little bit better on like organizing them. A lot of them had the same title for a long time. But this one has a specific title. It is, Let's Talk About Justice, Absolute Immunity. So you can go to the live and you'll always be able to recall this. But over here on TikTok, you guys, this video isn't saved. Right? So if you want to rewatch this video, you're going to need to go over to my YouTube page where it will be. That is at Tanawa Downing. Yeah, at Tanawa Downing on YouTube. Or you can go to Facebook. That is Tanawa.Downing.5. That's the only Facebook page I have. But it's only going to be available there for 30 days. But nonetheless, you'll be able to do that. And you can also go to my Instagram page, which is at Tanawa Downing. And it will also be there, although it's had a little working symbol. So there might be network issues with Instagram. But nonetheless, this video is available to you guys to be able to go back and review it. But at the end of the day, the whole point that I'm trying to get across here is that what you're hearing, from public officials right now is absolutely untrue. Absolute immunity does not protect people from their criminal conduct. It protects them civilly, but not criminally. And that's because a person is charged with criminal law, and the master is charged under the civil violation of the agent. So if the state creates a law that directs their agents to disobey the law, Constitution, then that master is responsible for the actions of the agent because they told him to do it. So for instance, the state of Washington, Article 1, Section 26 of its inferior constitution says, no grand jury shall be drawn or summoned in any county. So you have the state that created a law and is directing their prosecutors to go out and to charge people for capital and infamous crimes without an indictment by a grand jury, even though the Constitution of the United States of America says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So the state is now created a law and is enforcing a law that violates the Constitution of the United States of America, and that is directly a violation of the 14th Amendment. No state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. Just because that prosecutor listened to the state and did it doesn't make that prosecutor immune from criminal liability. Because Title 18 USC subsection 242 says any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. And when two or more persons conspire to advance that crime, now we have a conspiracy to deprive rights by and between those people that are involved, including a judge, a prosecutor, law enforcement, the jail and the jail administrator, CPS, whatever it might be. Whoever advanced the base crime of deprivation is also a member of that criminal conspiracy, right? Kidnapping, all these crimes are being committed. But you can't, again, hold the state criminally liable because the state is nothing. It's nothing, right? You can't lock the state up in prison, but you can hold the agent criminally liable for the conduct, the criminal conduct that they commit. But once you do that, then that gives rise to your liability civilly, and now you can file your 1983 suit. But you can't do it until that first step is done. And so that's part of the reason why we're doing these services for you all across the country. We're going to your cities and we're going to your counties, and we are informing your public officials for you that this crime is being committed, because that is a necessary step in a 1983 suit, right? 1983, that it is a violation of law, right? What waives the 1983 and the immunity is that it must be established law, and two, it must be known law, known and established law. It must be known and established law. So that's what we're doing with these services. We're making it known. They can't deny once we make it known, hey, this is the condition, right? You got your agents that are obeying a state statute that violates the Constitution of the United States. Now it's known. It's known to the attorneys, it's known to the prosecutors, it's known to the judges, it's known to the attorney general, it's known to the police, it's known. So this has given rise to your ability to be able to file your 1983. But before we can file the 1983s, before you can seek relief and damages, we first have to go after the agents for their criminal liability. And this was what the Supreme Court was getting at in Imbler versus Pac-Man, right? You guys are not powerless, right? The public is not powerless to be able to hold people liable for their misconduct or the crimes that they commit under criminal liability. Again, let me read this one more time for you guys. Let me read it again. Imbler versus Pac-Man, 424 U.S. 409, 1976. This is within our lifetime. Unanimous decision. There wasn't even a dissenting opinion that was written for this. All of the justices agreed with the written dissenting opinion. Absent the dissent, then there wasn't even question as to the validity of this decision. We emphasize that the immunity of prosecutors from liability in suits under subsection 1983 does not leave the public powerless to deter misconduct or to punish that which occurs. This court has never suggested that the policy considerations which compel civil immunity for certain government officials also places them beyond the reach of criminal law. Even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights on the strength of Title 18 USC subsection 242, which is the criminal analogy of subsection 1983. Okay? The agents can be held criminally liable for their breach of constitutional obligations. But we have to make sure that the law is known, which is part of the services that we're providing to your states, right? Because it's the first step in enforcing the law. The next step is that we have to get someone to actually take action. Under Title 18 USC subsection 242, the only agency with the authority, the lawful authority to be able to investigate that is the FBI, right? The FBI. That is the agency that is supposed to take control of this issue. Now, I'm going to tell you, I've contacted the FBI multiple times. I've informed them multiple times of this particular issue. I've informed them of the evidence that I have. Millions of criminal affidavits, actual verifiable complaints by victims of this particular issue. Not just the indictment issue, but the deprivation of rights under color of law issue. These are two issues that are interjoined under one single function, and that is that the state is depriving people of rights that are guaranteed by the Constitution of the United States of America under the semblance of lawful authority through an inferior state statute. No state statute can abridge the obligations codified in the Constitution because that would be unconstitutional. You're right, the FBI is not listening. The FBI has refused to acknowledge this. They refused to take action in this. And as a result, as far as I'm concerned, the FBI is opposing party. But the way that this works is that when government fails to obey the law, then government gives that law back to the people and we retain that power. That's the 10th Amendment, right? If we delegate powers to government and government fails to fulfill those powers, then the people retain that. That power comes back to the people and we retain it under the 10th Amendment. We have the authority to reassume that power. Now, all of you need to remember, under the laws of RICO, we're not talking civil RICO, we're talking criminal RICO. Remember, there are two different analogous statutes, one for civil liability for RICO and one for criminal liability RICO. I deal with criminal law. I don't deal with civil law. You want to get a suit for civil liability, go to an attorney. You want to deal with holding people accountable for their crimes, you come to me. I'm the expert in that. So there's two different RICO statutes. The criminal statute, what that says is that anyone has the authority, the lawful authority to prosecute a criminal RICO case. It is the only federal statute that anyone can prosecute. I can prosecute it. I can bring this to a grand jury. I can secure bills of indictment on behalf of people in the United States, acting as a private attorney general on behalf of the people of the United States for this issue under the criminal statute. I can't under civil statute, but I can under criminal. I can secure indictments. I can sign those indictments. I can act as a prosecuting attorney under this authority. You don't have to be an attorney. You could be any person as long as you're stepping up in the place of a private attorney general. Now, the reason why I am able to step in this position is because normally this case would be prosecuted by the state attorney general, right? Normally the state attorney general would prosecute it. But what happens when I notify the state attorney generals of the criminal conditions in this suit and they fail to take action as lawfully required to protect the people? Now they're opposing party. Not one of your state attorney generals is able to prosecute this case because they're all opposing party to this case because of the work that I've done getting out here and serving all of these public officials. That is the reason why we're taking this route. That's the reason why we're getting out here and serving these people is because they become opposing party in a RICO criminal case, which I have the authority to prosecute. So once all the attorney generals are removed, you have to have a private attorney general on behalf of people in the United States because all of these other attorney generals are all opposing party to the people. When an attorney general fails to enforce the laws of the United States, right? And they allow the deprivation of rights to continue under the semblance of authority under a supposed state statute, they're opposing party to all of you. They're opposing party to all of you. And as a result of being opposing party, that means that they cannot prosecute the case. I can. And that's what we're trying to do. We're trying to reach that point. The point to where I'm going to be able to go into the grand jury, we'll convene it, I will deliver to them all of the affidavits that I have. I will seek indictments as a result of the deprivation of rights under color of law that has occurred to all of you and your family. And if that grand jury, in a fair and neutral, unbiased proceeding, determines that yes, the crime of deprivation of rights under color of law has occurred, the crime of conspiracy to deprive of rights under color of law has occurred, the crime of kidnapping under color of law has occurred, and other crimes is ascertainable by the evidence on the record, if the grand jury makes a determination that there is sufficient probable cause based upon the prima facie evidence that I've collected from all of you, if they say that there is sufficient probable cause, then they will issue a bill of indictment. And that bill of indictment is not, no public official is immune from that bill of indictment. No one. Because one, you can't have nobility here in America. Because of two, the law doesn't provide immunity from criminal liability. And three, because we have the Supreme Court of the United States that said we still have the right to be able to hold public officials accountable for the crimes they commit under civil liability and civil statute, particularly Title 18 U.S.C. subsection 242, deprivation of rights under color of law, conspiracy to deprive rights. So not immune. The problem is that yes, you're absolutely right. The FBI is ignoring this. They don't want to deal with this. They're fully aware of this problem, but they don't want to address it, right? But we're not going to allow them to get away with that because the FBI must address it because they're the only agency that has the authority to investigate this crime. They must prosecute it. And if they refuse to prosecute it, then that means that they are permitting these acts of deprivation of rights under color of law to continue, and now they are also opposing party. Now the executive branch becomes opposing party to this. So I'm not giving up hope that we will still find honor somewhere within this system, but it's dwindling very, very quickly. There's not very many people left that have to be notified of these criminal conditions. So therefore, there's not much of an opportunity for anybody left to be able to step up and act honorably and to address this. So that's where I will come in under the criminal statute, under the lawful authority of a criminal RICO case, and we will prosecute them for the criminal conduct that they have committed, seeking indictments against all of the people that are involved in this. And remember, the grand jury has two main purposes, all right? The first purpose is to protect the accused from hasty or malicious charges by an overzealous prosecutor. So if you are being prosecuted by an agent of the state, that is a neutral, fair, neutral, unbiased, third-party decision maker that is there to protect the accused from hasty or malicious charges by an overzealous prosecutor. So that you don't get arrested for some arbitrary or capricious allegations by an agent of the state and are prosecuted without lawful cause or justification or unwarranted. That's the role of the grand jury with regard to individuals, citizens, people. With regard to government, a grand jury is there to investigate acts of corruption of government. That's why grand juries have been given unlimited subpoena authority and unlimited jurisdictional authority. They can cross all jurisdictional lines. A grand jury in the state of Washington can investigate any other state, and they can subpoena any other state for evidence in the course of investigating the base issue. And so as we talk about this, right, as we talk about the base crime being deprivation of rights under color of law, what we're trying to do is we're trying to show a typical behavior, standardized behavior that exists across all government agencies. And that is that the states are creating a law and enforcing that law through their agents that deprives people of rights that are fundamental and enumerated within the Constitution of the United States of America. All right. So I'll bring you up. Yeah, let's have a conversation. So this is forensics law. This is our brothers over there.
Yes.
Hey. Hey, how are you? I'm good.
Holy moly. I'm up here with famous people. Oh my goodness. Oh my goodness. What's up? What's up? Man, he is a boss.
Oh, no, that's you. Wait a minute. Let me turn this camera.
I'm only in one area, only in one little area. But I appreciate that, brother.
Man, you are doing the damn thing over there, man.
Thank you.
Fighting the fight.
Thank you.
Thanks for joining. Wait a minute, let me turn this thing around. If I can, I gotta figure it out. I'm not that great with all of these devices.
Yeah, me neither. Let me see here if I can flip my
Here's another
screen
one
around.
coming. Oh, let me see. Wait a
How do I
minute.
flip the screen?
Here we go. Flip it. I got it. Okay.
Let's see. Hold up. Look at me. Wait. Let me find my camera thingy thing. How you turn it on? Oh my. Somebody help me out here.
My hair need to be done. That's why I put a hat on.
Look.
1 second.
How do you do this here?
Don't feel bad. I'm the same way.
Yeah, I don't see how to, I see the 3 buttons down at the bottom. And how do you flip the camera around?
Let me see. I went down at the bottom where the 3 buttons are, and then you're gonna see the mic, and you're gonna see something else with sound.
It says settings. Yes. Here, voice, moderators, comments, blocked accounts. I know I got a long list of blocked accounts.
So I just invited Forensic Law up from TikTok, and this is a good opportunity to have a little discussion here. So let's do that, all right, guys?
That's true. That's me.
Hey, Trump!
What's up? Let me clean off the camera real
I don't
quick.
even know how this happened. I don't know how that
Listen, me neither. I was just watching his live, and he was busting down what he always does. And I just said, man, let me go live, you know. And here, lo and behold, oh my God.
Right on.
Oh, we don't.
So what I was
TikTok history.
what I was hitting on was the difference between civil liability and criminal liability, and the fact that absolute immunity, you know, as Stephen Miller and some of these other, you know, people are saying that these agents are immune, absolutely immune. They don't even understand immunity, right? Because immunity does not provide immunity from criminal liability. It only provides immunity from civil liability. And so, and even the Supreme Court said it in the unanimous decision, Imbler versus Pac-Man, 1976. And I'll read this to you because it sounds like you already got it, but this is Imbler versus Pac-Man, unanimous decision, 1976. It says, we emphasize that the immunity of prosecutors from liability in suits under 1983 does not leave the public powerless to deter misconduct or to punish what occurs. This court has never suggested that the policy considerations which compel civil immunity for certain government officials also place them beyond the reach of criminal law. Even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights under the strength of Title 18 U.S.C. subsection 242, which is the criminal analogy of subsection 1983. So my point was, my point in all of this is that before we can file the 1983, we have to first hold the agent criminally liable under the criminal analogous code. Because the agent does in fact have civil immunity. That's what absolute immunity says, that immunity from civil liability in the course of their business. That's what judicial, prosecutorial, sovereign, all of them say immunity from civil liability, but not criminal liability. So the steps are that if the agent breaks the law and commits a crime, you hold the agent criminally liable. And then once you do that under 1982, by direction of the Supreme Court of the United States right here, then you file your 1983 against the master who told the agent to break the law, to commit the crime. So, but this is the challenge. Like, how do we get these agents to be held criminally liable under 242, Title 18 U.S.C. 242? Well, that's what we're trying to do here. Like that's been the whole mission of this TUR and Justice Without Limits, is trying to bring the criminal action against these agents for the breaking of the law, so we can free up all of you to be able to file your 1983s without having immunity being an issue, right? Because before you can claim civil liability, you must first show that the agent committed, before you can sue for civil liability to the master, you must first show that the agent broke the law and in violation of civil liability. So,
Okay.
yeah.
I kind of disagree with that
Okay.
because you can show that the agent that took an oath of office and swore to uphold the Constitution, in that oath of office, it says that that agent swears to uphold the Constitution and not violate any person or foreigner's rights. Which, when you look at it, it kind of, to the novice, it kind of looks like, it reads kind of backwards, kind of to the novice. So if a person is looking at that, the thing is, that person took the oath of office, they swore to uphold it, but they turned around and violated what they said they would not do. So in that civil case where you can prove it, or I don't care if it was a criminal case, when you remove the case from the state, according to 1445, 1443, 1446, letter D,
Yeah.
when you move that case over, that lower court case stays until the federal court sees it.
Yeah.
And then, so when you move the case over, in your new case, under the Title 42, 1983, 85, 86, Title 18, 241, and 242, in that lower court case, you're going to always see what they did because they signed the documents.
Yeah.
It's always filed.
Yeah.
Yeah.
And I'm not disagreeing with. I think we're in complete agreement. And yes, the oath is what we're pursuing for the deprivation issue. You know, particularly on the grand jury, because you know the grand jury is what I'm attaching to because it's enumerated, it's written, we can all see it. But you know, when a state creates a law and then directs their agents to disobey the Constitution of the United States of America under an inferior state statute, the crime of deprivation of rights under color of law has occurred. Because that law is not law. That state statute is not law if it's contrary to Constitution, referred to Norton versus Shelby County. So, but we are attaching to the oath because the oath is what binds all the public officials to obedience to the obligations that the Constitution provides. And so, and this indictment issue is interesting because the absence of the indictment by a grand jury, the crime is actually committed by the judge. It's not the prosecutor who brings the incorrect charging instrument. It's the judge that commits the crime because the law says no person shall be held to answer for a capital otherwise heinous crime. The judge is the one that makes the decision to hold someone over, right? Therefore, the holding, the violation that occurs the moment that they're held to answer, which is the criminal conduct of the judge. But it also establishes a conspiracy as of that moment by the prosecutor. The prosecutor chose the incorrect charging instrument under an inferior state statute that allows them to charge by information, not indictment, as required by the Constitution. They can do that. But in order to hold someone over, that judge has the obligation of making sure that there is an indictment according to the Constitution. So it's the judge that commits the crime, but instantly establishes a conspiracy by and between themselves and the prosecutor. And this is important because the Supremacy Clause says the judges in every state shall be bound thereby anything in the Constitution or laws of the state contrary notwithstanding. And just as I said before, the Constitution references two different sets of judges. United States judges and state judges. This comes out of Article 3. Because in Article 3, it says the judges both of the United States and of their several states shall maintain their office while in good behavior. So prior to the article, it identifies the fact that there's two different judges, United States judges and state judges. Therefore, the Supremacy Clause, when it references the judges in every state are bound thereby, it's referring to state judges. Otherwise, it would have said the judges of the United States shall be bound thereby anything. So when the states say that they're not obligated to enforce the conditions of the Constitution, they are. The Constitution has identified two different judges, United States judges and state judges. Therefore, state judges, when it's referenced within there, the judges in every state shall be bound thereby. That binding is an extremely important term because bound is anything, an obligation is defined as anything a person is bound to do or forbear from doing. So there is an obligation that exists, and when you look at the existence of an obligation, every law creates an obligation, including the Constitution. That obligation can be seen from two different perspectives. From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So every law creates an obligation or a duty in order to preserve a right. Go ahead. Sorry.
Right. And they
Doesn't
violate.
their home rule charter, excuse me, I'm sorry, sis, their home rule charter, the state constitution, doesn't that give them even more layer of, being able to avoid the Constitution?
No. So every single state constitution within the first article has placed itself in subjection to the United States Constitution. So, for instance, Washington State's Constitution, Article 1, Section 2 says the United States Constitution is the supreme law of the land. So every single state constitution within the first article has placed itself in subjection to the United States Constitution, which means that if there's ever a conflict of law, right? If there's ever a conflict, then that judge or public official must employ what's called preemption. And they have to determine which law do I follow. Well, if the state constitution has placed itself in subjection to the supremacy of the United States Constitution, then preemption will tell them, I have to follow the United States Constitution because this one is subjected to it. So
How do you express that to that agent? Like, what's the solution for someone who's been, going through something similar? Their rights are being violated because Trump, I think he stopped the civil rights or anything, preferably that has anything to do with civil rights violations. Didn't they do something like hold that or something?
No. Not that I know of. I've never heard that.
Yeah, I could have sworn I seen something where he halted the civil rights cases or something like that, but I could be wrong. It could be some AI stuff I watched.
So what they did was they canceled all civil rights investigations under the FBI. So he directed his FBI and the civil rights group to discontinue investigating any civil rights cases. That was a couple months ago, right? Which is absolutely insane. But that's what they did. So they replaced all of the civil rights division of the FBI out of Washington D.C. and then they directed them to not continue to investigate any civil rights cases. That's where the 242 comes into play. Because again, like the FBI is the only agency that has the authority to investigate the deprivation of rights under color of law, Title 242. States don't have the authority to investigate it. Therefore, when a claim of a violation of 242 occurs, it must go to the FBI and they must investigate it. However, Trump did suspend investigations of civil rights cases. That was a few months ago that he did do that. And that's a very scary situation.
That is scary. And the habeas corpus, like everything there is just, to me, it all seemed like commerce was the way to go, and being in some kind of ministerial capacity.
Yeah.
Like the 14th Amendment citizen, they get crapped on. Even claiming to be that, it's insane. So staying out of that in a fiduciary role seemed to be the safest place for us.
So my big concern and what's been slowing me down is the concern about the suspension of habeas. Right, because we are coming in under habeas corpus because we're invoking original jurisdiction. We can't come under a certiorari because otherwise we're invoking the court's appellate jurisdiction, and we're not doing that. We're coming in under original jurisdiction, invoking original jurisdiction because we are saying that the states don't have jurisdiction to oversee a case in which the state is a party. If the state brings an accusation through one of its agents, then the same body of men that make up the state can't be presumed to be neutral and biased to act as a judge against you. That's codified in Article 3. It's codified in the Automatic Recusal Code. It's stated by Alexander Hamilton, James Madison, and John Jay. And so, we have all this that says that if a state is a party in a cause, then the state cannot oversee that cause because no man can be judge of his own case, the maximum law that exists. But in order to petition the Supreme Court, because of the Judicial Reform Act of 1925, which said that the only way you could petition them is through a writ of certiorari. A writ of certiorari is a request to review a lower court's decision. So what you're doing is you're invoking the court's appellate jurisdiction, and we had to get around that because we're going original. State doesn't have the authority to do this. Therefore, we are challenging jurisdiction, but we can't challenge jurisdiction under the certiorari without the court having the right of discretion. When we invoke original jurisdiction, discretion goes out the door because we are identifying an obligation, a lawful obligation, and no one can use their discretion abusively to violate the law, to break their obligation. So by going in under original jurisdiction, we bypass the Supreme Court of the United States' discretionary authority because we're invoking a constitutional obligation. but we had to find a different way to do it. And the way that we were doing it was through a writ of habeas corpus, because a writ of habeas corpus is an original civil action, right? It's not necessarily an appeal. It's challenging the validity of the detainment, which is the absence of the indictment by a grand jury. Because if you're arrested without the proper charging instrument, your arrest is unconstitutional. Therefore, you challenge the validity of the detainment. So we were coming in with the habeas on an original civil action, not doing a claims processing relief, not invoking the court's appellate jurisdiction, because there's nothing to appeal if the court didn't have the lawful authority to perform the arrest, therefore nullifying and rendering void everything after it. But the habeas corpus is the correct one to use, and you can send a habeas corpus directly to the Supreme Court of the United States. So they have subject matter jurisdiction to oversee a habeas, but then we have to worry about personal jurisdiction. And under personal jurisdiction, according to Article 3, the Supreme Court of the United States has original jurisdiction of any civil action in which the state is a party. Article 3, Section 2. So they would have personal jurisdiction, and we would go to their court under the personal jurisdiction authority of Article 3, Section 2, as well as also the subject matter jurisdiction of the habeas. But the problem is that if the president is considering, suspending habeas, as I've been afraid that he's going to do for years now, when we finally do this, if we bring this habeas forward on behalf of more than 700,000 people currently imprisoned unconstitutionally because they never followed the proper procedures codified in law, then we just lost the whole thing. Like all this would be for nothing, because they don't want to hear it, and they want to do whatever they can to avoid having to address this and rectify all of these unconstitutional alleged convictions that they've gotten. But the way that they do it is by simply suspending habeas, because they know I'm coming with a habeas. I've been telling them for years. That's the mechanism that we're going to use to get there.
Right.
Exactly. Right. I'm working on those two. I had the opportunity to solve 2 murder cases, and what was sad is both people hired expensive lawyers, and when I got the evidence, one of them, within 20 minutes of opening the file, I had to get the microfiche, and within 20 minutes I seen the ballistics, and it said that it was not the lady's fingerprints on the weapon, and they didn't identify whose it was. She did 35 years. Another guy, 20, he did so far 20 years. They haven't located me, rather, got back in contact with me to finish it off with. The weapon didn't have his fingerprints on it, and not only that, through a cross-examination and listening, everything they said was incorrect. But they still, so far, he's doing 20. He's did 21.
Yeah.
21 years now.
Well, what's the solution? I'm always looking for the solution. Like, we the people solution. Say every city, just say every city, that we get 100, 200 people, every city. And what would you say with the signatures that we would obtain? It wouldn't be, you see what they're doing with, peaceful protests, right?
Yeah.
That's not doing anything.
Yeah.
What do we the people? What do we the people do?
Yeah. No disrespect. Look how many people got on the live.
Yeah. I mean,
So,
it's not working. Look at the way these agents, I don't want to say the code agents, it's just completely, this is not protocol. This is not what we were raised, what we thought. My family, military, Marines, FBI, Senate. They don't seem like evildoers,
Right.
There's something going on. The puppeteers behind the system. But what do we do? We have to do something. If it's either that, it's going to be the evil kind of or, watch our words, right? The evil or. If we don't want that, we don't want that. But they're pushing the buttons. They're pushing the buttons, and it's like, how much can you take?
Right.
You just unaliving folks. It's just, come on, it can't be right.
Yeah.
Can't be right.
I agree completely, but
Well, there's certain things I can't say on here.
Me too.
So this is what we do have, right? What Jessica and I are doing is we're going around the country, and we're going to the legislative branch in particular, because we've already served the executive branch, the attorney generals of 47 states. We've already served the Supreme Courts of 47 states. they've been given a notice that their prosecutors and judges are conspiring to undermine the laws of the United States by the semblance of law under an inferior state statute to abridge, the enumerated rights codified in the Constitution of the United States of America. So on the indictment issue in particular, it's very, very simple, right? No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So when the state of Washington, Article 1, Section 26 of its inferior constitution says no grand jury shall be drawn or summoned in any county, that is an inferior state statute that is unconstitutional, that is being enforced by their agents. They have told the prosecutors that you can charge by information, not by indictment, under the authority of a state statute. That is the crime of deprivation of rights under color. That's the very definition of it, right? Any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. When two or more persons conspire to advance the base crime, i.e. a judge takes that information and says, this looks good to me, let's hold this person over. Now the judge has established the crime because no person can be held to answer. He's established the base crime of deprivation of rights under color of law. He's established a conspiracy by and between himself and the prosecuting attorney. Then when the sheriff goes out and executes the warrant that the judge issued, well, now that sheriff is also depriving of rights under color of law. They're also a member of the criminal conspiracy. And the moment that they take them into their custody without lawful authority to do so, and they hold them against their will, the crime of kidnapping has occurred. And it is a federal kidnapping offense, 1201, because anytime you have ransom, it is always a federal kidnapping offense, and they are holding them in ransom in the form of bail. They're saying, we're going to hold you here. We kidnap you, and we're going to hold you until you pay us, right? Which is the crime of kidnapping. And it is a federal kidnapping offense because the ransom is involved. And now we have a very significant situation where anytime that you have a deprivation of rights under color of law that occurs in conjunction with the kidnapping, the punishment as prescribed by law is unaliving. This is a serious, serious offense that they're engaged in. Serious.
It is.
So what Jessica and I are doing...
Isn't the sheriff a go-to? Doesn't the sheriff honor common law? Like, who do we serve other than, because we see that the buck stops right at the filing at the courts. Yeah. For a lot of people, they're not getting past that. So
Sun Tzu said in the book, The Art of the War, is that the first step to victory is that you must break up the alliances and pit them against each other. So we have an alliance of three branches of government. You have the executive, you have the judicial, and you have the legislative branch. They're in an alliance right now, right, to advance their financial interests. Well, the actual crime is by and between an executive officer and a judicial officer, right? Those are the two that are conspiring to commit these crimes. What we don't have in the courtroom is the legislative branch, right? And so in order to address this, we have to break up the alliances and we have to pit them against each other. And this is the narrative that I've been doing. So in the case of a prosecuting attorney who relies upon an inferior state statute to bring the incorrect charge and instrument, at first glance, you would say, oh, it's the prosecuting attorneys that are at fault for this, right? Judicial branch, you were negligent, but you weren't the one that committed the crime because you didn't bring the incorrect charge and instrument. So it's the executive branch that is committing this crime. Therefore, judicial branch, you were negligent, but you can mitigate your culpability by stepping up and holding the executive branch accountable for what they're doing. And at first glance, that's what you would say, is that it's the prosecuting attorney that's doing it. But that's not true, right? Now you got to look at the actual law and what the law says. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So the crime and the violation of the Fifth Amendment is when you're held to answer, which means that the moment that your arrest is ordered and you're held to answer. And that actually is the responsibility of the judiciary. So the new narrative is, yeah, prosecuting attorney, you were negligent because you relied upon the inferior state statute, but you didn't commit the crime. You're part of the criminal conspiracy because, yeah, you did, do that, but it was the judge's responsibility to make sure that the rights were upheld and that no person was held to answer without the proper charge and instrument. So the truth is, executive branch, you were negligent. It was committed by the judiciary, and now we pitted those two branches against each other. The judiciary has a way to say, oh, well, I'm going to blame the executive. We've given the executive an opportunity to say, oh, we're going to blame the judiciary. But what I was having a problem doing was, how do we get the legislative branch involved in this? Because they're all abstaining. All the United States senators up here in D.C., they were all saying, oh, well, that's a state issue. We don't get involved in a state issue. We abstain. And so we had to find a way to bring the legislative branch in and give them skin in the game so we can force them into oversight to correct it. So we had to break up the alliance with the legislative branch, and the way that we did that was through the emolument violation, because you can never pay someone to break the law, and you can never receive federal funding, right, to pay someone to violate federal law. If you receive federal funding for a function and you pay them to violate federal law, that is a federal emolument violation. So these states, that's why we're going to the county commissioners, the city councils. That's why we're now going into the state senates and the state houses, and we're informing them during public record, right? During a public hearing, we're informing them that for a city council, you pay the police to do their job. If the police in the course of their business is arresting someone with the incorrect charge and instrument, then that means that city council, you're paying for that crime to be committed. And now you have skin in the game. So by informing the city council of the condition and informing them that it is a crime to pay someone to violate the law, then we've enjoined them in. Now we brought skin in the game. They can't abstain anymore, because if they pay those police officers one more time after being notified and made aware of the criminal conditions, that goes from negligence into willful criminal conduct. Now you're aware that you're paying for these crimes to be committed. The reason why we're going to the county commissioners is because budgetarily they're responsible for the prosecutor, county attorney. They're also responsible for paying the sheriff's department. They're responsible for the county jail, and they're also responsible for the county court budgetarily. So if the courtroom is being used to facilitate the abridgment of a constitutional obligation, then county commissioners, you're paying for that to be done. And now you are committing a crime because you're paying for a crime to be committed. If the sheriff is going out and performing an arrest, then go ahead.
Let me say this, because it's just like this. Everybody has insurance, and like I said, I don't like saying a lot of stuff on TikTok. Any platform.
Risk management.
Anybody that has insurance, if you affect the insurance, that person can't work. I just gave
There's
y'all
a better way.
Yeah.
That's one avenue right there. That right there is one avenue. 100%. 100%. But listen, to the folks that don't do it, sis, the folks that don't know how to go this way, right? We, the people, are still going through it. If one person gets their way out of this, right? One person succeeds and says, okay, well, I go over here to risk management. I contact the commissioner's office. I know who to contact. I've done it. They called me down to the mayor's office. I know exactly what buttons to push. I'm one man, right?
Yeah.
I've seen instances where an individual was on federal parole, right, and turned in their birth certificate to the Secretary of State. The whole restitution that they had to pay was taken care of, wiped out, right? And they were released from parole. If everybody is bound by this social contract with just the birth certificate, okay?
Yeah.
Even the Native Americans have a surrender certificate. What is stopping us from severing this thing that they have, right? That social contract. That's basically what it is. As long as we're under or we're adhered to the social contract, then we are subjected to what's going on. What's the solution? You know, if I say go ahead and just return or rescind or reversionary interest, whatever the case may be, that seems to be the only way to stop this governing, right? And we start governing ourselves. We stop dealing in their FRNs or their USDC token that they got coming out. If we keep having our hand out and participating in their game, then we're subjected to their rules, right?
Yeah.
So how do we sever that? We, the people, have to start spending our own amongst ourselves, barter and exchange amongst ourselves, and just cut down that system.
Yeah.
Hit the cherry tree. You gotta cut it out. But all this going back and forth, the court stuff is not my thing.
Yeah.
Like I said, there's a lot of stuff I'm not gonna say on here, but I'm just gonna say this. If you have insurance with your insurance company and you have a car accident and you get more than one case or whatever claim filed, what's gonna happen? Are they gonna insure you? No. They all have insurance.
They do. But making the claim, that's the part, you know. Finding people going to the recorder of deeds office and locating the oath and the insurance bond, you know, it's as easy as that. Logging into the website, the court website, going to the recorder of deeds. I'm from the Commonwealth. and it's common sense. All right, everything that we have accessible, we got the Capitol building here, we got the federal building, we got all of these things right at our fingertips, and it's pretty fair. But when you get into dealing with judges and that immunity that they have, it gets unfair, you know.
So the immunity, one of the ways that we're sidestepping the immunity is that, again, does a state have the authority to oversee the disposition of a dispute in which the state itself is a party, right? So in the body of men that make up the state, when they bring an accusation against you, can the same body of men be presumed to be neutral and biased to act as the judge against you? And the answer is no, right? So, and this is codified in Article 3, Section 2, where it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if a state is a party in a cause, the state no longer has jurisdiction to oversee the cause, and jurisdiction is statutorily granted through the Constitution to the federal judicial authority, not the state judicial authority. And this was stated by Alexander Hamilton in the Federalist Number 80. Alexander Hamilton said in the Federalist Number 80, he said that the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So if there's a dispute between the state and the citizens of the state, then the federal judicial authority must extend. He went on to say right after that state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in his own cause or in any cause with which he has the least bit bias or interest. So if the state tribunal cannot be presumed to be impartial if it speaks for itself, then that is why the federal judicial authority of the Union extends anytime that a state is a party in a cause, according to Article 3. Now, if you were to go to the Federal Judicial Code, Title 28, 455, which is the automatic recusal, what that says is it says that a judicial officer has a mandatory, non-waivable, self-executing duty to recuse himself if he is an officer of either party. Again, officer of either party. These are judicial officers of the state, therefore they have an automatic, mandatory, non-waivable, self-executing duty to recuse themselves because the Constitution has created the obligation. The state judges don't have the authority to oversee a case in which the state is bringing accusations against them because the federal judicial authority of the Union must extend. Federal court must be the judge, and therein lies the separation of powers that the Constitution provides. The state brings an accusation, state can't judge it. Therefore, the federal judicial authority extends. If the federal government brings an accusation, right, then under Title 455, that is a judicial officer of the United States, which is the party. Therefore, the same applies in federal court. That would mean that the state judge, the state judicial authority must extend, and now you have the separation of powers. Whatever government is bringing the accusation can't be the same government that's judging, and that's what the Constitution was implying. Now, one other thing I want to say is that I'm not doing this from within a courtroom. I'm not an attorney. I'm an advocate. I deal with law enforcement. My degree is in law enforcement, substantive law. So I'm out here doing what law enforcement does. I'm out here serving notices. I'm out here collecting evidence. I'm out here, trying to bring a criminal.
Say this from
I appreciate that. We appreciate you. I mean,
I don't really
that's
want
what
to talk that much on you. Is he breaking up? He's breaking up.
No, not for me.
I can't hear you.
No, not for me.
I hear him.
Breaking
I
up.
hear him. Yeah, I can hear him clearly. But
So what we do have right now is we have collected a little over 2 million affidavits. These are criminal affidavits of deprivation of rights under color of law from people who have been charged. Yeah, people that have been charged by way of information, not by indictment as required by the Constitution. We've collected them from every single state, almost every single county now. We have affidavits from them. So this is the weapon that we're building, right? This is the weapon that we're building because these are verifiable complaints. It's prima facie evidence of per se crimes. All we have to do is show that there was a lawful obligation in the Constitution and government didn't fulfill it, and now they've already implicitly invited punishment. So these criminal affidavits are not criminal complaints because that's what initiates the criminal adjudication process. But they are the evidence that's necessary to start that if that's the direction we have to go. Do we have to start trying judges and prosecutors? I think that's going to be a really messy, very difficult path to take. But that's up to them to decide. We're giving them an opportunity. We've gone to them and said, you guys are breaking the law. If you want to continue to do that, you're going to be known as a criminal, and we have all the evidence to be able to prosecute you, right? But if you don't, then you must return to the established rule of law.
Prosecution.
Sorry? Yeah.
Who would do the prosecution?
I would under RICO. So the criminal statute, the federal criminal RICO statute allows for any person to act as a private attorney general, which is why I provided notice to all of the state attorney generals, is because when I go to a state attorney general, they're the ones that would normally handle a prosecution of this nature. They're the ones that would normally go to the grand jury and secure the indictments and everything else. But in the case of a federal criminal statute, or a RICO statute, anybody can prosecute that, right? So I have the authority to be able to do that once I've informed all these attorney generals that you are allowing your agents to commit a crime, and they failed to take lawful action as required to correct the unlawful acts of their agents. They're now opposing party. They can't represent the people on the prosecution because they can be joined as defendants in the action. That's the laws of criminal conspiracy. That any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of commission of the same, neglects or refuses to do so, may be joined as defendants in the action. So upon having been provided...
affidavits?
Sorry?
Are you still accepting affidavits?
Absolutely. Absolutely. No, we need as many as possible, because at some point in time, this massive amount of evidence that we have, if the Supreme Court wants to continue to ignore it, then great. We will drop 13 pallets of affidavits off to them, and they can decide what they're going to do with 2.5 million capital crimes against their agents, right? I mean, that will be the case that we will file at the Supreme Court if they refuse to acknowledge this and concede and work with us to fix the problem.
That's what we want. We want remedy. It's unfair. That's how I feel. But I'm with the separation of state and church. That's what I educate my folks on. All right, not the people that are in the frying pan, not the people that are cooked right now. I'm talking about the individuals that are out here, and I want to safeguard them. Right?
Yeah.
There's a separation. Get the things out of your name. Start operating from this veil. And live a peaceful life. But to our brothers and sisters that have fallen or continue to fall, what can we do to because a lot of them aren't gonna read. They're not gonna do the things that we've done thus far.
Yeah.
So we have to at least protect the sheep.
Yeah.
What are we gonna do? I don't know anything else other than proactive measures. As far as going to court and filing claims, et cetera, that's a very long road. We the people there should be a quicker remedy than some pushed off case 6 months, years, 2 years. They're gonna outlive us.
Yeah.
Mm-hmm. The government's gonna outlive the whole system, and they're just passing it down through their bloodline.
Yeah.
Through the insurance. Yeah.
What?
If you can't get insurance, you can't work.
Mm-hmm.
What we're trying to do again? So we're trying to serve on the emolument violation. We're trying to bring the legislative branch in and ask them to provide oversight, because again, by pitting the branches against each other, we're breaking up the alliance, and we're now giving the judiciary and the executive branch a different branch that they can point the finger at, because the judiciary can say, oh, well, legislative branch, if you wouldn't have created the law, or if you didn't pay these public officials, the crime wouldn't exist. Therefore, the legislative branch is responsible for all this. So we're trying to pit all three branches of government against each other, giving them a narrative that they can follow to point the finger at a different branch, to try to give each one of the branches a way out, right? Because
legislation is the problem, in my opinion.
Absolutely, I would agree. I would agree.
They created this system to attach the child to the maritime law from birth. Right. Bottomry, the whole maritime thing, that's what they did. So how do we affect, is it Parliament? Who would, override that, us, we the people only, what can we do? Because legislation is not, it's full of crap, full of people that don't really care about the voice of the people,
So again, we're doing parliamentary services now. We're not going to the executive branch because we've already served the highest executive officer. We're not going to the judiciary anymore. We've already served the highest judicial officer. We're going into the parliamentary services and providing parliamentary service of the crime that they are committing by paying these public officials to break the law. So again, if If the police are going out and performing an arrest without the lawful or proper charging instrument, then the city council, that parliament, is responsible for paying for that crime to be committed. And now they're notified and made aware, and if they continue to pay, now they're, knowingly and willingly committing the crime. For the county commissioners, they're responsible for the judge in the courtroom and the sheriff. If the sheriff is executing a warrant that's unconstitutional because the incorrect charging instrument was in place, then the county commissioners are paying for that to be done. And then we're going into the
dual citizenship, though. So wouldn't there be an international body? Because
So-
they could just jump rope. They could just sit here and do stuff domestically and then go to the protection of international. Especially, up their trust with a provision, that migration provision, because most of them are operating through an entity. Folks think that just because their name is out there that they're operating as that. Their name is a business. They created something that they can just up and move it to another jurisdiction. So it's just, I'm always looking for the solution, brother.
Yeah.
That's it. We
So-
can talk all day, but
So we provided a 2-page script, a narrative that can be read at city councils and county commissioners. You can get that from the website. That's justicewithoutlimits.org. So you can go out to justicewithoutlimits.org. It's the script of what I say. Right? There's probably 180. We've done 110 services to parliaments so far. That's city councils and county commissioners so far. We've done 4 state senates and House of Representatives. So we're now moving into the state legislature because they prepare the budget for the judges. So they're paying judges to commit these crimes. So we got to get into notify them as well. But we've done 110 of these so far. And the narrative, the script can be downloaded from the website, and we need help. I mean, we need help getting out there because I'm telling you right now, they're getting nervous. They're getting absolutely nervous. We had our first city council or county commission call us just last week after 110 of these that said, you know what, we don't want to be responsible for these crimes. How do we fix this, right? We had a senator come in, or a representative come and ask us the same thing just a couple weeks ago. A United States representative come and say, how do we fix this? Right? We spent Thanksgiving with a state representative at his house going over this issue, and he agrees with it to the extent that he is now submitting a amendment to the state constitution to require them to comply with the Constitution of the United States of America because he agrees with it. So we've sat down with governors. I mean, the sheriff in Hennepin County took off his patch off his uniform and gave it to me and said, "You're right." Now we also sat down with judges in Alabama 2 weeks ago. Sat down with some judges in Alabama, and they said to us, "You're absolutely correct. Like this is gonna happen, and you're gonna win." But they had some advice on how we should move forward from this moment forward. But they said, "You're absolutely right." And they not only said that, but they said, "We've known about this for years. We've just been hoping that it doesn't get exposed." 700,000 people imprisoned on direct facial constitutional violations because the judiciary hasn't followed the Constitution of the United States of America. That's a big deal, man. That's a black mark that they don't want to admit. They've known about it for years, and they've just chosen to ignore it, hoping that it won't ever be heard. And that's what we're seeing right now.
The ignoring part is what concerns me. Just that ignoring part, because of the things that we have learned along this journey. And even from judges, directly from a judge, said, "I can't speak to you unless your name is in the book of life."
Yeah.
Right? So if we are civilly mortuus, then the things that we do, and that's why we're failing, is because we haven't taken care of something, procedurally from our own offices governing our own affairs. There's something missing proactively, not after, in the mix of things and going and filing against insurance or bonds, etc. There could be something that's missing here. If the judge is going to tell us that much, that the reason why I can't acknowledge you is because your name isn't in the book of life. Well, it's so much across the board. We're talking every state. I'm hearing stuff from international waters. People share all kinds of information with me, and all I look is like, where is the solution? Where is there some nexus point where something is missing? Obviously, because if you consider me to be an infant, abandoned, black. These things here are what put us in that little box, that category, that 14th Amendment situation there that they can govern over and take you from your home, just rip you out of your home.
Yeah.
All I'm going to say is Title 42, 1983, 85, 86, Title 18, 241, 242. Show it in the lawsuit. And I have seen it where they have settled out of court.
Yeah. Yeah.
You got insurance.
Book of life.
If an attorney gets 3 claims or complaints at the bar association, it can't work. Who is on the cases? Attorneys.
Yeah. See,
It's not that hard.
the attorneys, an attorney is taught to follow adjudicative law, which adjudicative law deals with the adjudication process. So an attorney is trained to remove liberty. Like that's what they're taught, to take away freedom. So all the laws that they rely upon are laws that remove freedom.
And he has insurance.
He does have insurance, yeah.
3, he cannot work. All of these people have the same attorneys going to the same courts. You can look on the legal newspaper or anywhere and see how many attorneys are the same ones going to the same courts for foreclosure or anything else. Get together and go and do what you all need to do.
Like what do you call it? Like one of those massive complaints, or a what is it called?
Nope, you talking about a what's the name lawsuit with everybody be on it? Those
Class action.
No. I got that from an attorney. He likes to do them because he doesn't have to tell you how many people were involved in a class action lawsuit.
That's it. Yeah.
And he cuts up the money as he wishes.
So I'm using a class action habeas because you can class habeas, but we're coming in under one single habeas so we don't expel other people's rights to be able to do it. So by placing everybody into the same procedural situation, everybody had the same issue happen to them, that someone charged improperly and then someone conspired, to advance it, so on. So the affidavits are exactly the same. All 2 million of these, 2.2 million of these affidavits that we have are all exactly the same. Nothing is added to them, which places everybody into the same procedural situation. And if we can litigate in one single habeas, then you get what's called vicarious relief. But here's the evidence of it. This has happened 2.2 million times right here. But by not bringing multiple habeases in, then we have 2.2 million chances to win this, right? But the way that a class action habeas works would be that if one overcomes the procedural situation, they all overcome it, and then you get vicarious relief. But we don't get paid, right? You can't ask for money in a habeas, right? Because the damage is different. What we're asking for is restoration of the liberties that the state deprived under the semblance of lawful authority. So restore the person back to the point of which the fundamental right was deprived in violation of the Constitution of the United States. But that's the only thing we can ask for. No money, but money comes next. Yeah, go ahead.
But people need to be compensated for their injuries. It's in the insurance.
Yeah, I agree completely.
I'm telling y'all what I know, not what I heard.
Yeah.
I'm just telling you.
What 100%. All that I'm trying to do is I'm trying to make it so that they can easily win a 1983 by establishing the law that the public officials are breaking. The first part, showing that there was a law, all these public officials broke the law, and now, you can seek damages. All these people deserve to be made whole from the damages that the state, caused them and their family.
There's not enough money. There's not enough money to do that. It's just not. I don't see it. I don't see it happen. Exactly. I don't see everybody in the U.S. Those that have been violated. Everybody in the U.S. Everybody under this Constitution have all been violated in some sense. And I don't think there's any amount of money that can make us whole again. Other than we the people. Yeah. Re-amending something, like we have to start making some changes to things to prevent this abuse of these positions. So it's got to be a we the people thing. I've been saying this for the last few years. Is like, if I can say this all day, but it doesn't mean anything. Me just singularly going in here and doing anything, it's lonely. We have to stop the division. We have to look at the rights that are being violated every day. His rights is violating my rights. Yeah. That means you would do the same thing to me. So if we don't take some kind of proactive steps or prevent this stuff from happening again, we're going to be stuck in this situation, man. And I don't think this administration gives a crap right now. If you're not in a certain figure of, you know, tax brackets. They don't really care, you know.
Yeah. Yeah, all that I'm saying is this is what we're trying to do. It's not going to solve the problem, but this is what we're trying to do, and so people can download the script to read to your city council, county commission to support us if you like the things that we're saying here. All we're trying to do is raise awareness on the issue so that we can make the court stop ignoring this and actually address this and let me debate this issue. And if they don't want to, then I guess we'll cross that bridge when we get there. You're right. There's not enough money to be able to pay for all the damages that government has caused to the people. But again, I can only say let's cross that bridge when we get there.
Their insurance is with HCC. Tokyo Marina is overseas. The city's insurance is located up on Upper Dyke in Michigan. I'm telling you what I know, not what I heard.
That's still singular. You're talking about one individual going in there filing a claim against the insurance. I'm talking about a whole community. There's not enough money to pay everybody. There's not. You know, there is not. The dollar is already.
They're going to keep on having the money, gonna make money because it's in insurance. So everybody's not going to get paid at the same time. Everybody is not going to get the same amount. But if you look up HCC Insurance, Tokyo Marina, they're overseas, and look how much they're worth. They making money every day. A person get $2 or $3 million, so what? These people are making money hand over fist every day. They're invested in stuff. I'm telling you what I know.
Yeah.
I'm not telling you what somebody said. I'm telling you. I know firsthand knowledge. I know.
I think, and you're right. I think that, you know, under the regulatory law, I guarantee that the insurance companies have to have in assets, liquidatable assets, the value of the policies that they write. You know, so if it's $2 million per instance, what is a conceivable number of violation? I don't know, but the insurance companies, in order to write a policy, they have to have the money to be able to support that underwriting. So,
Right.
you know, they got to be backed by the banks, and there has to be sufficient money.
There's other ways after that as well. I'm not, like I said, I'm probably telling too much over here anyway.
Yeah.
But it's some other things behind that.
Yeah.
Margin call.
And
I mean, I know
I'll be kind enough to talk to both of you gentlemen off of here. How about that?
Right.
Okay.
All right.
Yeah.
As long as we help in the community, that's all I really.
How about that?
It's enough workload for me to sit there and get the calls that I get. I'm sure you get them. Forensic, I'm sure you get them.
Right.
It's too many people for one individual to sit there and manage. So, and then the competency or the, you know, the overstanding, whatever you want to say, but that part that you need to get. If you do not get this, then this is not a battle that you want to take.
Yeah.
You know, it's going to take you 4 years, 5 years to catch up with all this law. You get, and that's a long journey.
Right.
It's a long journey, but if we can do it, we can do it together. Like he says, AI can do it.
Let me ask you two questions. Right, quick. I'm sorry. Go ahead.
No, I was just reading the comment. He said AI can
Okay.
do it. That's what they're going to do with those 2 million affidavits that you got.
In the comments.
Unite.
The assets. Believe it or not, it's not even what you all think at all. You're welcome. Who was that? Blue somebody? Blue Dior? My pleasure. Why is it private? Because everything don't need to be discussed on the public, in the public. Like I said, I say it all the time. I'm not going to discuss all that. I got family members. You know, sometimes when you do things, you can't talk about it.
Yeah.
Everybody
Definitely not on
yes.
Not on the C word here. You can't even say the C word on here. You know, answer it, right? You can't even say that. You can't say censorship. They flagged me one time for talking about it. I was like, well, there goes that. But you got to just at least get a community of individuals and guys. You know, you got to have a plan. If you don't have a plan, just all the talking is just talk.
Yep.
I'm not into just talking. I'm into like, what's the solution? What's step one of this? Let's take care of that, you know? And like I said, the things that I've learned along this journey, proactively, I've prevented a lot of people from going into certain situations. Had they not taken the steps, they would have been dragged off.
Yep.
You know, there are proactive measures that you can take to protect yourself. But if you're caught up just with your driver's license and you're just floating the seas of commerce with nothing, no flags on your ship, no accolades, no kudos, they're gonna just yank you on and just take you away, you
Right.
know. But you have to do proactive things, and that's the part. It's most of the time once we learn these things, it becomes proprietary, and you're like, well, I'm doing all this work. I need to make $1 because I have a family to take care of. So, and you just don't put this stuff out on there. Every time you attempt to share the information on these platforms, it's yanked down.
Yeah.
So we have, yeah. Listen, forensic my nerves. I know that's right, y'all.
I'm serious. No, I'm not. No.
Listen, all right. No doubt.
And if we get
Listen.
better than that, hell to the no.
Hell to the dog. Listen.
No, it took me 15 years to get it right.
Right, right.
And I'm not gonna sit up here blatantly be like, hey, y'all do this, no.
Right,
People
right.
learn their own. Nobody taught me any of the stuff that I learned.
Mm-hmm.
Nobody. Okay, after 2 brain injuries, nobody taught me anything. After I lost my memory in a car accident and all of that, nobody taught me anything.
I didn't know that part.
I lost my
Not a scratch on that face. Look at that. Not a scratch on that face. Look at you.
It cost enough money. It cost enough money. Trust me.
All right.
Yeah.
Let me see.
So there's a couple questions here. One is, where do you obtain the script and where do you obtain the affidavits? They can both be obtained from our website. That's www.justicewithoutlimits.org. You can download them there. The instruction to the affidavits to fill them out is also there. And then there's a P.O. box that we have in North Carolina that's receiving them. And so you would send them to that location. Be sure to follow the instructions, including everything we put. You must sign the lip of the envelope as a tamper seal, making sure that if it gets opened somewhere along the way, that we have a way of knowing that it was opened. And make sure it's signed in blue ink. Just follow the instructions in it. But you download that from justicewithoutlimits.org. And if you guys want training, Jessica, every single Friday, 4:30 p.m. Eastern, every Sunday, every Sunday at 4:30 p.m. Eastern, she does do training to coordinate with everybody that's across the country providing service. We thank all of you for helping us out in doing this and getting out there and serving your local city council and county commission.
Let's go.
Yep. Y'all go ahead and follow him. Make sure y'all get that insurance, y'all.
100%. We're in agreement. It's just I'm trying to deal with the
I'll talk to you off here. Yeah, a lot of stuff I don't.
Of course.
Say.
Yeah.
Mm-hmm.
All right, guys.
All right, brother.
Tawana, somebody said, can you're breaking up on the phone. Can you put that in the chat for them?
Somebody put it in the chat already.
Yeah. Justice.
Justice Without Limits, spelled the same way. JusticeWithoutLimits.org. O-R-G.
Justice can be just ice. Look at the word.
Yep.
Mm-hmm.
Justice
Oh my God, that's scary.
without limits.org.
Yeah, I got a book about what happened to me. It's called Just Ice.
Mm.
Yep,
They do
false
not give a
security
shit
in the
about
gated community.
AIDS. They do not give a shit about AIDS. Rights. Oh, okay, rights.
Yeah.
It's like playing.
And remember, I want to say that we have 2 different affidavits. One is for the absence of the indictment by a grand jury. The other is for the interference with the familial unit. These 2 issues are directly connected. We can't deny the correlation between the 2, because for every child that you remove from the love and care of mother and father, that child grows up into an adult that has an 80% likelihood of going to prison over their lifetime. So the trauma that we're inflicting upon these children through the abuse of power by removing them through the CPS system, that is feeding into this phenomenon known as mass incarceration. So every single one of these prisoners were once a child that had something happen to them that tragically changed the trajectory of their life. These are someone's children, and their mother and father want them back home as well to get the love and support they need to be able to heal from the trauma. That's why we have both these issues connected, and we can't deny the correlation between the 2. So there's 2 different affidavits, one for destruction of familial unit, one for the absence of the indictment by a grand jury, and both of these are deprivation of rights under color of law that we will be pushing to litigate together.
Okay. All right.
All right, guys.
I appreciate you. I'll get with you too.
Thank you, guys.
I'll push it out there. I'll
You know,
definitely push it out there.
DM me, both of you. DM me,
Yeah.
and then I'll tell you.
All right.
All right, cool.
Sounds good.
All right, then.
Nah,
Peace and
cool.
love.
So
All right.
So we had this week we did city of Norfolk, which is also a county. For some reason, in Virginia, the cities are also counties. There is no separate county for Norfolk, for Portsmouth, for Hampton.
What? That's new. I
Yeah.
didn't know that.
So I think it was in the 70s. I think it said, but nonetheless, so there are some counties, but down here, these independent cities function both as a city and a county government entity. So the city is actually responsible for the jail and for paying the sheriff's department and for establishing the judicial system. So there is no county within Hampton Roads area. Every single one of these cities is an independent city that has abolished county government, and now that is absorbed into the city function. So we have served city of Norfolk, which includes county of Norfolk, and we also, earlier this week, we were in Durham. We did Durham County in North Carolina. So we got you guys covered in North Carolina some more. And we also served the Virginia State Senate and House during a public hearing for the budget, the 2026 budget. So we served the Virginia State Senate and the Virginia State House of Representatives or House of Delegates during that service. So we are continuing to push forward in what we're doing, but we have a service later on tonight, and then we have some plans for later on this week, and then I believe we're heading back down south again to start helping Mississippi, Louisiana guys and get them served next week. So we'll be back down in the south then next week. All right, that's our
In
schedule.
the house from Virginia, Melanie.
All right. All right. All right.
Okay, y'all got the information. Tawana, do you pay attention to your DMs?
No, but you and I are connected, so it does pop up. Like all the ones that I'm not directly connected to, they come up under a different connection, and I don't really do much with them. But you and I are connected, so I will see your DM come up, right? And I'll connect down here with you, brother.
Yeah. I think did I give you my number?
I don't think so. I can go in and look, but I don't think so.
Okay.
I'll send you a message.
I'll put it in there, and then I'll give you my direct number.
Okay.
All right,
I'll
cool.
DM you.
It was a pleasure speaking with you, man. I appreciate you jumping up here. It was cool.
Yeah.
Thank you. I don't know how that happened, but it must
Yeah,
have
me
been.
neither.
It popped up saying that you asked to join. That's what it said.
Wow, I did not know that.
My finger slipped.
Wow, that's
Okay.
dope. I like it.
Whatever. All right. I'm like, well, yeah. Let's do this then.
I like
right.
it, definitely.
Yeah.
Thank you.
All right, guys.
All right. Thanks, guys. God bless. Thank you.
Peace and love.
Thank you.
All right.
Yeah, please. So now that if I want to stay on, how do I stay on? Y'all two gotta.
Okay, so over here, I see you guys are asking about Cameron. I'll reach out to Cameron. Cameron doesn't have my new phone number. I haven't been giving out my new phone number, so he's probably texting my old number. I believe he has Jessica's number. You can text her, but so I see that. I'll reach out to Cameron. I'll reach out to Cameron, see what's up. Maybe we'll get back on that show too. So again, this week we Monday we were in Durham County, North Carolina. We served them. We were hoping to do multiple counties, but it didn't work out that way. Yesterday we were in Norfolk. We were going to do Portsmouth as well. We were there, but they were going late. And we had a conference call with Republic that we had to get on by 8:30. So we ended up having to pull out of providing service to Portsmouth. So we didn't get that done. We do have a service later on tonight that we're doing, and we don't know the rest of the week where we're going. Other than I believe on Friday we're going to be up in Delaware. We have a service in Delaware on Friday. We're going to do. And then again, next week, we're going to be heading back down south again. So one more time, if you guys get contacted by anybody asking you for money, it's not coming from us. We will never contact you asking you for money. We never contact you offering the affidavit. If you guys want to take it upon yourself to donate, We're not soliciting it. It's on you guys. If you guys want to do that, if you want to support us, great. If you don't, that's fine too. It doesn't change what we're doing. But if you guys want the affidavit, we're not giving it to you. We made it available. You guys can take the effort to go get the affidavit. You guys believe in it. You want to do it. That's fine. We're not soliciting. We are enforcing the law. This affidavit is a verifiable complaint from you. You are the victim. Therefore, it's not coming from me. It's coming from you. And so we will never contact you asking you for money. We'll never contact you saying, hey, do you need the affidavit? You guys know where to get it. JusticeWithoutLimits.org. You guys go out there, download the affidavit if you want, and send it to Justin Carey in North Carolina. That's entirely up to you guys. But if you do want to donate, the safest way to do it is from the website. So www.justicewithoutlimits.org/donate. It's one of the pages, donate. And that's the safest way to do it because all of our donation points are right there. You just click on it and it'll take you, whether you want to use Cash App, Chime, Venmo, PayPal, Zelle, whatever it is that you want, they're all right there. You can click on it and it's the safest way to do it to make sure that the money comes to the TER and to Justice Without Limits. So that's the safest way to do it. I would highly recommend that if you guys want to donate, go to there. And go there. But we will never, ever, ever contact you asking for money, and we don't accept donations in any way other than Cash App, Chime, Venmo, PayPal, and Zelle. We don't accept Apple cards or anything else. So please help us with these scammers, and let's shut them down and not let them steal from you guys anymore because that's not what we want. We want you guys to hell we want to get this done. I mean, that's what we want. We want to get this done. We want to do that. We're not making money off this. We're not getting rich here. You guys have been amazing because you guys have been keeping us, in a condition where we're not having to worry every single day about where we're going to sleep or what we're going to eat. You guys have really been helping us, focus on this task. So I appreciate that so much from all of you. So again, you can download the affidavits from justicewithoutlimits.org. You can download the script to read and the notice to provide to the City Council, County Commission from the website justicewithoutlimits.org. It's under the docs tag or tab, so /docs. Top left, you'll see docs. You just tap on it, and that'll take you there. And so the script to read, the affidavits to provide, the instructions for the affidavit, the notice to give to the city clerk or county clerk is all right there. You guys can get it, and we need as much help as we can because there's a lot of people that still have to get served. We are going to continue to do this until the court stops ignoring this and agrees to hear the case, and we get this finished. All right, we're not going to stop until we reach that point. All right. So love you too, guys. Love you too. I think that's it. So that's it. We are again starting to move into the legislation, to the state legislatures and starting to get them served. So every single opportunity we have to get into a state Senate or state House to serve them through their committees, we will be doing that because they are the ones that pay the judges to do their job. Therefore, the federal emolument for the judiciary violation comes from them. We need to get them served as well. That's what Jessica and I are going to be focusing on. So we need you guys' help with the cities and the counties for the emolument. And again, this is a federal emolument violation because you cannot receive federal funding and then pay people to violate federal law. That would be the federal emolument. So this isn't a state emolument. This is a federal emolument because every single state jail, every single state prison system, every single state court system, they're all funded by federal grant funding. So if you receive federal grant funding to pay judges, right, and you end up, and this federal funding can also be the Title 4D, Title 4E, right, because all of the judges, their retirement accounts come from Title 4D, Title 4E. We know this. So when the judges' pay comes from federal funding and then the state pays that state agent to abridge federal law, now you have the federal emolument violation. And that's what we're bringing forward to city councils, county commissioners, and all the rest, and now into state legislatures. So this is real, it's valid, and and we are seeing action, right? We are seeing changes in positioning, changes in narrative. Just last night in Norfolk, the county attorney or the city attorney said, well, we appreciate, everything that's said and agree. Well, great. So you agree. What are you going to do about it? Because if you agree, then if you continue to allow it to continue and you continue to pay these people to do the things that they're doing, if they're committing a crime in the conduct of their business, that crime is not immune. Going back to today's original discussion, that no person is immune from criminal liability. They're immune from civil liability under absolute immunity, but they are not immune from criminal liability. Every person can be held criminally liable for the criminal conduct that they commit, right? And just as the Supreme Court said in Imbler versus Pac-Man, and I'm telling you guys, go out and reference that. This is Imbler versus Pac-Man, 1976. We emphasize that the immunity of prosecutors from liability in suits under subsection 1983 does not leave the public powerless to deter misconduct or to punish what occurs. This court has never suggested that the policy considerations which compel civil immunity for certain government officials also place them beyond the reach of criminal law. Even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivation of the constitutional rights on the strength of 18 U.S.C. subsection 242, which is the criminal analogy of subsection 1983. So you file a 1983 against the state, and you file a criminal suit under Title 18, 242 against the agent. That's what I'm working on. That's the part that we're dealing with right now. Is we are trying to bring the criminal conduct forward so that all of you can file your 1983 suit and not have immunity being an issue. But before you can seek civil damages, you must obtain criminal damages first, criminal liability. You do that against the agents. So the agents are immune from civil liability, but they're not immune from criminal liability. State is immune from criminal liability, but the agent is not. All right? Thank you guys so much. God bless. And talk to you here sometime soon. Thank you, Facebook. God bless everybody. Thank you, YouTube. God bless, guys.